velocidade das transformações do mundo. Mas, na verdade, esperávamos que essas mudanças seguissem um ritmo imposto por nós mesmos, segundo nossas próprias necessidades. Como se as mudanças fossem previsíveis ou fáceis de assimilar. Até que o mundo parou e tivemos que ouvir as notícias e ver de frente a nossa própria vulnerabilidade. Nenhum de nós esperava experimentar uma situação como esta, mas aqui estamos, imersos nela. Mas será que conseguimos aprender alguma coisa com tudo isso? Ser capaz de aprender é a marca maior da nossa condição humana. Mas tivemos que nos superar para lidar com o que chegou. E agora ficou patente o que é verdadeiramente importante para nós. Entendemos que fazemos parte de um grande ecossistema e que cada um depende dos demais. O desafio é aprender juntos os novos caminhos da transformação digital. Fazer diferença com inovação, empatia e coragem. É com esse espírito que a equipe da LD Soft está aqui pronta para ajudar você a fazer cada vez mais pelo seu cliente, oferecendo meios para você trabalhar com mais produtividade e eficiência, mesmo nas condições inesperadas do trabalho totalmente remoto. Nossas ferramentas oferecem aquilo que você precisa para dar atenção a tudo que realmente importa e que só você pode fazer. Assim, ter tempo para oferecer ao seu cliente os resultados de excelência que ele sabe que vai receber de você. Por isso, vamos continuar firmes, para que em breve possamos destampar nossos sorrisos e comemorarmos as novas conquistas juntos nos desafios que estão por vir. LD Soft, potencializando o universo jurídico através da tecnologia.
Não é nada simples equacionar a miríade de controvérsias que podem surgir quando o assunto é distribuir as rendas resultantes da transmissão de eventos esportivos. São inúmeras as partes interessadas: jogadores, técnicos, times de futebol, estádios ou arenas, locutores, produtores e distribuidores de áudio, cinegrafistas, produtores e distribuidores de imagens. Dentre estes, os transmissores de rádio e televisão e agora, também, os distribuidores por meio da internet. Nossa lei, que regula parte desses interesses e constitui os chamados direitos de arena e direitos de transmissão, na visão de alguns, está caduca. Na de outros, o melhor é deixar como está. O fato é que propostas de um novo marco legal para esses direitos se encontram em discussão. O Flamengo e outros times causaram polêmica ao empregarem seus direitos de transmissão para transmitirem as partidas de que participam apenas por meio de seus canais no YouTube. Qual a consequência desse tipo de decisão? Para entendermos melhor o que está acontecendo e as alternativas em jogo, teremos na Arena especialistas na matéria, sob a moderação do não menos entendedor de esportes, Paulo Parente.
Good morning, everyone. Here we are in yet another panel of the 40th Congress of Intellectual Property from ABPI. I'd like to thank everyone for participating and the organization of the event for inviting me as a moderator to this panel. I'd like to thank the sponsors, institutional sponsors. Before I actually start the panel, I'd like to give you some housekeeping elements. We have simultaneous translation and questions after each speaker can be sent through the chat. We have a chat. I can see already now, David, Felipe, Tanya, so on. I have two monitors, so I'd like you from the audience to address your questions and comments through the chat. Our starting point for this panel, Broadcasting and Arena Rights, has to do with the Provisional Measure 984 edited by the federal government amid the pandemic. Because of social distancing, a number of sectors in the economy were locked down, especially the entertainment business, and even more the sports sector. So the idea was to regulate sports competitions to mitigate the effects of the pandemic, were the backdrop of this panel. So the provisional measure came into effect in June during the pandemic, and the main change was about the Article 42 of the Pelé Law, the Pelé Act. Article 42 established arena rights, which is nothing more but the article dealing with sports entities. We're going to talk about soccer clubs, collecting and transmitting the image of players. The arena rights also have to do with individual rights and image rights, which belong to the individual. So what's the main change? There are 4 articles in the provisional measure that have really created an incredible amount of reaction in entertainment, especially in the soccer area, especially for those who are fans of soccer. You have been keeping up with what's going on with broadcasting. Article 42, before the provisional measure, established that sports entities and soccer clubs, they needed to authorize broadcasting together. So what changed with the provisional measure? As of its coming into effect, the entity, it is the dominating entity is what is going to give the authorization. That changed, entirely revolutionized contracts. And obviously this created a lot of reaction. So it deals with arena rights to be distributed to players. In the former text, the percentage paid out to players and the collective club was distributed through trade unions, and now and during the provisional measure, it is then now up to the club. Now there's a new temporary law for labor contracts, and also changes into the Pelé Act, sponsorship of companies exploring radio and TV broadcasts, sounds and image broadcasts. So with the provisional measure, there was a revolution in this sector. But what happens is that on the 15th of October, it is no longer into effect. The Congress has not voted it. And on the 13th of October, Pedro Paulo presented a new bill 489 establishing rules for broadcasting sports and creating a professional league in Brazil. In addition, André Figueiredo, a congressman, also introduced a new one, 4876 bill, determining that the rights to broadcast the rights belong to the main club. So the idea is to discuss with experts the main legal consequences before, during, and after the effect of the provisional measure that actually is no longer valid since the 13th of October. I will start by reading the CV of André. He's a journalist, has a degree with the University from Rio Grande do Sul, has been working with sports for 30 years. He has participated in the main sports events of the world. At Globo TV, he was a reporter and host for years. He is also a partner in a law company. He has post-graduation in sports law. He is a professor at the Catholic University. And he has written a book called Press 38. André, you have the floor. Welcome. And it's up to you now. Paulo, thank you so much for your comments. I'd like to thank ABPI for the invitation. It's a pleasure to be here, exchanging ideas. Pleasure with Professor Valmir Camargo, one of the main references I have in the legal arena, to talk about this interesting topic. During the introduction in the video shows the relevance of this topic that is very current because of the provisional measure 984. We have never discussed broadcasting rights as we did in 2020. It's an interesting topic, but it's not new. We have a bill from 2017, an article establishing broadcasting rights that have to be part of the dominating club. So for those who are interested in the game, it's very important, is a very important debate, but that has been triggered by the wrong way, in my view, through a provisional measure that transmission broadcasting rights were not supposed to be under a provisional measure, because this could be considered against the Constitution, but it definitely led to a necessary debate. So it was a unilateral decision without the participation of the main sports stakeholders, and from day to night with major impact, because nobody knew what was going to happen. And then the legal system completely changed and the business changed. And I'll explain why. We have here on the screen the slide I prepared. I don't think, I cannot see it. Yes, but now my slides are on the screen, as you can see it. So for you to have an idea of the amount of the size of the problem, if we go on broadcasting rights and Article 42 of the Pelé Act, the first content you'll find in Google is this one. It belongs to the sports entity, the arena rights. And if you go a bit below, you will see Article 42 of the Pelé Act saying they have the right to negotiate and authorize. So this lower part, the second one of version of the Article 42 of the Pelé Act is what is in effect today. And the upper one was in effect until Thursday last week, and it went on for 120 days. And what was valid? It was the previous tax that started going into effect on Friday. So this is is crucial for legal stability for sports industry and so on. This brought major instability. This is a very important discussion, but as I said, in my opinion, through the wrong way. So we have an idea of the problem. It changed the broadcasting arena rights, led to instability, and it's really a problem for the sports business. It brought a topic to the agenda that's very important to the soccer industry. So it's very important to talk about this. And what has been proposed by ABPI is very important. We cannot forget the debate. We have to talk about broadcasting rights again, but then talking about taking all stakeholders, sports entities, players, lawmakers, law council, and also talk about something that is related to broadcasting rights that the provisional measure forgets or oversees. I'm sorry, I can't move on to the next slide. We were training, it worked out. Well, there you go. So why are broadcasting rights so important? Because they're a very important business to the economy of the soccer economy and for soccer clubs. Because they can't split the budget. They are hostage of television broadcasting. In 2019, these are numbers from Sports Value, was worth 6.8 billion reais and 1.9 billion from TV broadcasting rights. So 28% of the total revenue. It's a lot of money. Today, soccer clubs depend on the sale of players and broadcasting rights. So soccer clubs need to work out their budgets, their management, business management, and invest in match day and advertising. But it's very important to understand that there's a revolution in communication. People need to look at it, and people don't look at it, and we don't have the laws. And all the numbers I have shown, the fantastic numbers I have shown, and the role in the economy, which is streaming, which is our next slide. And I'd like to touch upon the role and the revolution when it comes to communications. This affects the issue that has been discussed through the Provisional Measure 984. Until very recently, Paulo, Vladimir, and those listening to our panel, we had the non-cable TVs with the monopoly of content in Brazil. Until 5-6 years ago, they were a monopoly. They were the main source of information to people. They consume content and products through the main TV chains, Band, Rede, Globo, and so on. And broadcasting rights were negotiated with these companies. However, in the last few years, we have seen a revolution on how we consume and we deliver. And Globo doesn't compete anymore with Band, Reddit TV, and so on. Now, the competitors is Disney, Amazon, Apple, and obviously that will have an impact on broadcasting rights. And all the companies you see on the screen, they see in soccer an interesting product, because soccer is still entertainment. So when we say that Globo is competing with DAZN, it's not true. But also with Amazon Films, because we're competing for people's free time. And that is the main fight of content producers. They need to create a cartel, a portfolio event, so that people sell their free time. Disney Plus is a new application that is going to kick in Brazil in November. When it was launched last year in the United States, only on the first day, there were 10 million people who bought the subscription. So there is also a package with Fox, a global purchase of Fox. It's all under Disney Plus. It's a more complete package, including ESPN sports programs. And this is going to come to Brazil in November, Disney application. So the first day subscribers went beyond expectations, but it's not a surprise. You know, the Brazilian market understands how you would deliver and consume content. Streaming came with the future. DAZN and Apple came in. DAZN took away the soccer cup from Global. We have league matches through streaming. The fact is, conventional TV is no longer everywhere on building people's imagination. Streaming is already everywhere in the US. There has been an article, very interesting article on a Brazilian, that a number of 20 sports, Olympic sports, are already being broadcast by streaming. So the sports entity gets organized. You can maybe hire a content producer, but then they are going to stream through their channels to their social media. So then the monetized events too. So today, broadcasting rights is going to add. How much is this going to represent in terms of numbers for the soccer economy? Conventional TV, and until recently through social media, the content, for example, the national news were published on the news, but then that was repercussed on social media. And now it's the other way around. It is the national news talking about news that actually started on social media. So nobody expects at 8 o'clock to get informed the national news. What they want to see at 8 o'clock is the consequences of the information they already got during the day. So everything, all the structures that we have not kept up with this. So this provisional measure has triggered an important debate about streaming and about the need to talk about broadcasting rights under this new perspective, this new idea. I think the provisional measure 984 brings important positive points. You know, there's less chance of a blackout. The master club broadcasts the match, and that you don't need to have an agreement with a visiting club. So it attacks also the content producers' monopoly. More companies producing content can negotiate with soccer teams. Also, important once the master club and the home club gets the content. It doesn't mean that it has to be individual. Small clubs can become 5, 10, 15 clubs together and negotiate broadcasting rights with much more power. And then you confer power to smaller clubs. So there is not such a gap between small clubs and large clubs. So then you have a sports balance, because if you have one team that is way stronger than the other, and there's always going to be the same result, there's always going to be the same winning. We may like it in the beginning. After, it's interesting, and then you stop watching because it's no longer exciting. So the sports needs to regulate the financial balance and the sports balance in order to make sure that there is surprise in the results, and then the fans are interested, and to feed the enthusiasm of the fans. Because of the uncertainty, I want my team to win, but I am not 100% sure. Negative points for sure. The absence of a dialogue with stakeholders. Also, from day to night, surprising the sports market with a legal framework without having a discussion with stakeholders. And then it does not include streaming, precisely. So, and then the provisional measure is now no longer valid. Now we go back to Article 42 of the Pelé Act, and why that Paulo and ABPI and Vladimir is here, and why we're all here. Why is it important to talk about broadcasting rights? Because it's a critical subject for the economy of this business. And giving it to the master club, to the home club, is the best way for soccer in Brazil, but it has to be discussed. So we need not to talk about the provisional measure, but about the broadcasting rights. Everyone that reacted to the federal measure now need to go back to the debate about broadcasting rights. We have 2 bills at Congress talking about this. But are we really conducting the need for a debate that we complain so much? Are the sports entities worried about this? Were the fans worried or are they going to complain after the bill is enacted into a law, into an act? So the PL number 68 of 2017 really treats broadcasting rights, but also deals with all the legal framework that's needed to avoid problems. When you are delivering to the master club, to the home club, the rights, this was carried out by a committee of jurists. I think Professor Vladimir Camargo is going to speak in more detail about this. In Article 206, that all rules existing be valid for the World Wide Web. It's from 2017, and it's already covering stream, but it treats other elements too, but also broadcasting rights, for example, private corruption, crime. It's a revolution, in my opinion, but this would create a new general sports act. It would deal with broadcasting, fan statute, law for fostering sports with the right legal protection. 13 jurists were studying it for 2 years, discussing with sports movements, many meetings worked out with players and sports entities. And it brought about this critical debate and the whole sports chain. Does it need improvement? Yes, maybe. Why aren't we going to have this at the Senate? Why can't we have a new debate among sports stakeholders to place improvements on the bill? So we cannot miss this historic opportunity. the provisional measure, just to wrap up my comments, my initial comments, it was nothing urgent during the pandemic, especially in the pandemic where there are other priorities. I think the only urgent article on the provisional measure was to allow for a specific period of time, a 1 month contract for an athlete, because the law used to say 90 days because the championships didn't finish and their contracts were running out. But the provisional measure is very important. So we're going to take the positive side, or are we going to insist on taking the wrong way, forget about it and not debate it? And when an act on broadcasting rights, everybody's going to start going in uproar and saying that there was not enough debate. So this is the main teaser I'm bringing about to you. Thank you so much, Paulo. Congratulations on the choice of topic. It is critical to sports, to sports rights, and for the soccer industry and the whole sports industry. there's always going to be equality and fair play and seeking best result, and also commercial and financial elements. In Brazil, there's always one or two teams because of financial reasons are ahead of others. So we have to be very careful because there are impacts on sports law. I will not speak so much about the provisional measure. I think it's a shame. It was a wasted opportunity. Investors are discouraged, and the government simply abandoned this in Congress. And because of the pandemic, everything is delayed. This could be a priority. But in the new legislation, after the provisional measure has lost validity, there is the obligation of a team to constitute a league to be able to be entitled to the rights. This is a legal outrageous. It violates the 5th article of the federal constitution. Talks about the negative right, not just positive right. I have the right of association, but the Constitution bans the obligation of associating. So also item 1 of Article 117 violated by this. This has a major impact on the linking the whole Brazilian system against what the federal constitution advocates and guarantees. I could talk beyond. No one should be obliged to be associated to hold the rights, which is a personal right and a sacred right. So in addition to the General Sports Act, which is running in the National Congress, I had the honor to be rapporteur of the bill that is running in the Congress, and the proposal for the constitutional amendment number 9 in 2017 that would solve the broadcasting rights. But I'd like to remind you of something else I participated in. I was rapporteur for the General World Cup Act 12633 of 2012, the General World Cup Act, in its Article 12, saying that FIFA has the exclusive rights related to image, sounds, and whatever expression ways in events. The events are the World Cup and the Confederation Cups, including Explorer, etc., and banning transmission or retransmission. Article 13, registration for official competitions during the events, including the press representatives, is going to be carried out only by FIFA according to the terms specified by FIFA. So these are 3 important definitions. 2, I mentioned. Article 12, FIFA is the only holder of all rights related to image, sound, as well as the expression of the events. A very comprehensive concept to provide stability, legal stability for the World Cup in Brazil, illegal capture of image, and so on. This was very perfected. If we remove FIFA and have host a team, it would solve the problem. Article 13 also, FIFA was responsible for registering. So then you avoid piracy, people from being at the place of the competition. There's another one I didn't read. It was not during the FIFA World Cup, but it's also part of the Brazilian law and the Pelé Act. I negotiated on the government side. We managed to force FIFA to comply with this legal tradition of distributing for free images from competitions, so that other channels that were not right holders could use only for the purposes of journalism. And this is how it was during the World Cup with FIFA. And I advocate that this should be also protecting freedom of expression and protecting communication rights. This is an incredibly wealth of good knowledge, and this team, I could speak here forever, and I am available to answer questions and hear your comments. Thank you so much, Paulo. Professor Vladimir, I'm the one thanking you. I think that our audience has really been lucky with a fantastic explanation of the legal framework of the provisional measure, as well as the differences between of image rights, arena rights, and all the elements on tax, commercial contract law. It's so many areas of law that are of so much interest for those involved in this area. Well, what's for sure is there's a lot of confusion to come as it's happening. Provisional measure with a formal law, and now the provisional measure is no longer valid, and the contracts that were executed because these contracts are were executed during the pandemic. Sometimes they were long-term contracts. What I'd like to know from you, well, first of all, thank you once again, because this has been a kind of a magnum, both by Professor Vladimir and Andre. So as of 3 bills for the General Sports Act running still, and another 2 bills, how do you see today how things are going to move on from now on, and what are there are some lawsuits. I think there is a global lawsuit that is already happening. So what are the problems you expect from the provisional measure not being valid anymore and the contracts executed during the period of the pandemic? And being compulsory for creating a league. I am 100% in agreement. You shouldn't be forced to create a league, but I think it would be interesting to have a league. We're looking more at the soccer side of things that could better distribute broadcasting rights, maybe a league negotiating collectively so everyone individually gains, just as the Premier League. What do you have to say about this? I'm sorry, before you actually respond, I'd also like to ask the audience. I'm keeping an eye on the chat. I see that Andre and Vladimir have got so many compliments. Everybody really enjoyed the presentations, I can see here, but I'd like you to then make your comments. So I'll give the floor then, let's say, Professor Vladimir. So you make your comments, and Andre, if you will, go ahead. Well, the bills that are running were submitted with the expectation that the provisional measure was not going to be entertained. When we talk about losing its validity, it was extinct. Even the rapporteur, the rapporteur didn't express himself before the 120 days. So the first comment or the first reaction to your teaser, that it should be preserved. The effects should be preserved for the 120 days. I agree that this was done in a confused way, was even maybe violating the Constitution. But anyway, it produced legal effects during 120 days, as you, Paulo, have said. We have a perfect legal act covering a contract rights. I don't know if people understand, but people who are interested in this topic, we're waiting for a decree from the National Congress defining the effects of the provisional measure during the 120 days. They have 60 days to issue a legislature decree. According to my experience of around 30 years following these topics, well, 30 is maybe an exaggeration, 25 years in following up on this topic, and Betsy, I don't think we're not going to have any problems to say that, it did generate legal effects during the 120 days. You also said, Paulo, that we went back to the old text of Article 42. When we talk about provisional measure, this is a common. So this happens often because not all of them are approved, and they're not approved as they were submitted. So when it loses validity, the provision that was changed, then you go back to the old text. So this is automatic, and this is what's going to happen. So Article 12 is going to go back with the same text. That's what I respond to people when they ask me about it. And as for the bills that are running, they have been submitted because the provisional measure lost validity. There have been some abusive claims, such as the creation of leagues, but I think the best way is to have a bill. The National Congress should actually see a way of analyzing the bill for a general sports act. There's going to be an organic and serious discussion to update the Pelé Act. It's very difficult to enforce. Article 42 is not very well written. It's not very well adapted to the current situation for a new General Sports Act at the Senate. It's not a bill from me. It was the Juris Commission bill for the federal Senate that should be changed. I actually advocate that there should be changes in the actual definition of broadcasting rights compared to what we wrote in 2016, 2017, so that using the bill that is running in the Senate, there should be a discussion on broadcasting rights as well as other topics related to sports. We had an issue with the sports tribunal flexibilizing the way sports justice becomes more professional. So I'm just mentioning a number of elements that just to make sure that you understand that there's so much discussed in terms of sports. So this is what I had to say in terms of my comments to your teaser. And we should be a little more aware of the negative impact. In my opinion, this was an attempt, a political marketing attempt to use a political time to something that was negative because it attacks discussion in sports. And investors, when they see something like that, they say, well, there's no way I'm investing there, when there was a way forward, and suddenly it becomes fake news to prohibit to the previous plenary session. Thank you so much, Andre. What are your comments on this? I already have questions from the audience. You're muted. You're muted. Paulo, you also teased us to think about a collective bargaining and the main leagues around the world and the need. Professor mentioned the broadcasting rights being treated in a systematic way, looking at the football and a change in delivering the broadcasting rights to one single team that would impact the players' contracts and sponsors. Today, the current text before the provisional measure, a company that had the rights of 10 teams in the Brazilian Championship could, with the current text, about 98 matches. If you change the law and delivering to the home teams, they would only broadcast 180. So brand exposure was not the same. The contracts with their sponsors, with players and sponsors. So the change has to be seen in a systematic way. We need to have a general act. We need to discuss a new general sports act. We have to look at the Bill 98 at the Senate about collective bargaining. The main leagues negotiate in this way, and this is not an imposition from the government, from the state that makes it this way. It is an organized sports movement. If you allow me, Andre, Portugal's different. I think Portugal, Spain also has an intervention from the state, and I'll explain it. But in most cases, it is the leagues organizing themselves. In Brazil, in the 1980s, we did have in Brazil people who are above 30 as we are. In the 1980s, we had the Club of 13, which was that the sports movement understood that the Brazilian Confederation of Football did not attend to the needs of the teams, and they got organized spontaneously. They had a powerful movement with a lot of legitimacy collectively. They organized a championship, and the Brazilian Confederation had to accept it. And then they started an embryo of the first league around the world, because the first league in the world was organized in the 1990s. And because of other interest, because of they decided to negotiate with the television companies, the global broadcasting company. So the Club of 13 collapsed. But there's no doubt that this is the natural way. This is an independent movement in sports. An autonomous and transnational sports act. The laws have to be the same all over the world. If you get organized internally, obviously you have much more bargaining power. I'll give you the example of Spain. There was a government intervention because there was nothing in the constitution that precluded the interference. And why did they have to do it? Because the organization of teams didn't manage to protect themselves. They started to negotiate Real Madrid and Barcelona fortunes, the other clubs less, and the small people, nothing. Only Real Madrid and Barcelona were winning the matches. So there were only there was no interest. And then the public was not interested. The product lost power. And then the government went in. And from now on, it's going to be collective bargain. Wow, they decided 50% of the negotiations was for all clubs equally, 25% for sports performance and 25% for viewership. The other clubs would gain enough to have more competitive teams. The competitor in the field, it's your partner in business. To keep the fun in the sport is critical, and this is from a sports movement, domestic sports movement, respecting independence of sport. This is interesting. If you think about it, Brazil could have the same type of distribution. Today, there are 20 teams in the Brazilian Championship. And if you have a distribution like that, I think the less influential teams, I don't want to say the smaller teams, but those that are not so big will benefit, and consumers will also benefit, because otherwise, for a rule that was under the rights on the home country, have more freedom and more economic gain for teams negotiating for pay-per-view streaming and television rights. But on the other hand, at the end of the day, there's going to have the same problem as the Portuguese championship. You have a number of teams, and then only 2 teams getting to the finals. And the same case of Spain. So this should be discussed, debated under the bills as a gain for everyone, and not just for one large team in this country to benefit. Everyone should benefit so that the championship becomes more interesting. Now I am going to go to Q&A. Vincente, well-known lawyer, he's also worked for FIFA. He asked the question, how are we going to solve the image rights in video games, especially for players? A number of players are filing lawsuits. Couldn't we have a collective bargaining as we had in ICAD? Is there an initiative in this sense, or is there a better solution? He didn't tell who he's asking the question, but both, whoever wants, may answer. Should I go first? Okay. The electronic sports first. Vicente Rosenfeld, I'd like to thank you for your question. You and I consider esports as sports, actually. So there are still problems in esports, especially the possibility of interference from third parties when it comes to sports yield and a level playing field between competitors. In esports and video games belong to the publishing company of the software. That's a problem for sports. We're not thinking about it as bad faith. That's not. But there is the possibility, and the law should control this, manipulate results for commercial purposes. When you change the codes in the software, may favor a top player. That's the name of the players, a pro player. But I consider it as the sport. So then I don't agree with an icon. Manuel Pubino, who, when he died in 1998, but the International Olympic Committee has open negotiations with entities representing sports and the Olympic Games for young people. This has started already. And regardless of that, let's say we come into a consensus. It's not sports. Let's say it's esports is not sport, which I don't believe is going to happen. People involved in these online broadcasts in electronic matches, they would still be holders of their image rights. So both for broadcasting rights and image rights, the debate is the same as in football. That's why it has to be done together. Everything I said, you can use in esports, just as Andre said. Paulo said it too. It's better to have a number of entities negotiating broadcasting rights instead of individual negotiations. And I agree with this. What I don't agree with is the obligation to do so. This would also be true for esports. If players could organize, just as there are trade unions for players, for arena rights, as I read in Article 12 of the Act, 5% of the arena rights for players, it is the trade unions that distribute the money, the 5% of the player. And the same way, this already is working for players. That's just for, not just for physical sport. So it is the Pelé Act that's working on this. I agree with you. I do see it as sports. It's esports and a sport. Andre, we are nearing the end of our panel. Any comments? Yeah, very quickly. The main issue. This is a huge revolution, and our legal framework is not prepared for this. But this is a fantastic business that the turnover is billions, and we need to discuss this urgently. But just to have you an idea, the main issue, the main question mark that we need to ask here, developer, which should be an e-sport federation, but it has the monopoly of the game. Okay, do they have the interest of becoming a sport? Look at all the obligations. No, they would have to create sports justice system. As Professor just said, you have to distribute broadcasting rights to the players. Are they interested in being a sport, or do they prefer not to debate this in legal terms? I think this is a good question mark. But if it's treated as a sport, then it has, I agree that it needs to be treated as sports, and even to bring more security for esports operators as well as players. So much. There are different categories, and there are players making a lot of money in games. We need legislation to protect those people, but that legislation is not there yet. It's not in place yet. Thank you so much. Great. I think this is a question, comment. Glabier Leonardo's, the Club 13 sold itself to the Confederation, and it led to the confusion in 1997. So it's just this is typical CBF. So we're not going into the fan issue. So this has been a reason for so much discussion with this. I'd like to ask you if you have any final comments so I can wrap up our panel. And I have learned so much. I think this has been fantastic to have these two incredible authorities, real influencers in this area, and moderating a panel where I learned so much, learning every day. So I'll leave Andre and Professor Wagner with the final comments. I'd like to thank you for this opportunity. This has been a great event. This has been very well organized. You are really spoiling us, the people you invited to participate. It has been a great pleasure to participate in this ABPI Congress. I'd like to thank the members of the association, especially Dr. Paulo Parenti, for having opening this channel with sports law. There's not one sports law. It communicates with all areas, legal areas. I work in administrative law within sport. A lot of people don't know what this is. There is this relationship with sports law and public entities. Just to give you an example, and intellectual property is, there's no way we can talk about sports law if we don't talk about intellectual property. ABPI, please continue bringing us this space and stimulating the debate. We're always going to be willing and humbly participating with you in these initiatives. Thank you so much. I would like to thank you immensely for your participation. Andre, Professor Vladimir Camargos, I can see from the chat, the panel has been a great success, and thanks to the brilliant knowledge. I'd like to say that ABPI has a number of study committees, and some of these committees definitely will make efforts in discussing these bills involving sports and bringing the contribution of experts in intellectual property for the improvement of sports management in Brazil, not just for football, but for so many sports we have: handball, tennis, basketball, volleyball. So we are a really source of sportsmen, and having people such as you debating these relevant topics, let's try and bring Brazil, at least in this aspect, to be in the leadership and not a failure out abroad. So thank you so much for your participation. Thank you to all participants that have sent their questions and comments. We wrapped up exactly punctually at the right time, and I give the floor to Erica. I'd like to thank Erica and the organizers of the technicians. It's not an easy task to organize such an event. So the whole team, ABPI team, and the whole organizing committee, without you, this wouldn't have happened. Congratulations, the seminar has been a success.
Já faz algum tempo que falamos da velocidade das transformações do mundo. Mas, na verdade, esperávamos que essas mudanças seguissem um ritmo imposto por nós mesmos, segundo nossas próprias necessidades. Como se as mudanças fossem previsíveis ou fáceis de assimilar. Até que o mundo parou e tivemos que ouvir as notícias e ver de frente a nossa própria vulnerabilidade. Nenhum de nós esperava experimentar uma situação como esta, mas aqui estamos, imersos nela. Mas será que conseguimos aprender alguma coisa com tudo isso? Ser capaz de aprender é a marca maior da nossa condição humana, mas tivemos que nos superar para lidar com o que chegou. E agora ficou patente o que é verdadeiramente importante para nós. Entendemos que fazemos parte de um grande ecossistema e que cada um depende dos demais. O desafio é aprender juntos os novos caminhos da transformação digital. Fazer diferença com inovação, empatia e coragem. É com esse espírito que a equipe da LD Soft está aqui pronta para ajudar você a fazer cada vez mais pelo seu cliente, oferecendo meios para você trabalhar com mais produtividade e eficiência, mesmo nas condições inesperadas do trabalho totalmente remoto. Nossas ferramentas oferecem aquilo que você precisa, para dar atenção a tudo que realmente importa e que só você pode fazer. Assim, ter tempo para oferecer ao seu cliente os resultados de excelência que ele sabe que vai receber de você. Por isso, vamos continuar firmes, para que em breve possamos destampar nossos sorrisos e comemorarmos as novas conquistas juntos nos desafios que estão por vir. LD Soft, potencializando o universo jurídico através da tecnologia.